90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. My special guest today is attorney Stephen Mitchell Sachs, and he is an employees' rights lawyer. He only represents employees and has been doing so for over 40 years, and is the author of the recent book, Fired: How to Protect Your Rights and Fight Back If You're Terminated, Laid Off, Downsized, Restructured, Forced to resign or quit. And we'll talk about how he can help people concerning all those situations in the next half hour. Stephen, welcome back to Law You Should Know.
Thank you so much, Ken. It's a pleasure to be here.
As we are emerging from COVID, the workplace is in turmoil, and having an employee's rights lawyer is more important than ever. As people age, as the nature of the workplace changes, the workplace can be in turmoil. So are you busier than ever with people who are unhappy or are being forced out, or conditions made even more adverse, or people being challenged as they try to have a safe workplace?
Unfortunately not. I mean, yes, unfortunately. And that's basically many functions. One is, I think after 41 years and representing thousands of people, some people that I've represented when they got fired like 5 years ago come back to me again, right? And they tell their friends and their relatives and their neighbors. And also, most people these days find me online. I've been blessed to have excellent 5-star Google, Avvo, and Yahoo reviews. It seems that reviews are important these days. When people are looking for a lawyer, one of the first areas they go to is reviews. And I've luckily, serviced my clients well, and people seem to be pleased with me. So I have a high rating, and people come to me all the time.
And we'll talk about the process of some of the important issues in the minutes ahead. As we emerge from COVID, why is this such a hot topic now? Employee rights and people, unfortunately, being fired or laid off, or not given conditions they can work with to successfully return to the office.
When I started practicing in 1980, long time ago, the laws were not in favor of the individual. People would be fired, and they really had no place to go, nothing to do. And now, if you think about it, so many laws have been enacted all the time to level the playing field. So it's a whole new world for the individual rights in sexual harassment, right? In hour and wage litigation. Oh, it's astounding. Discrimination litigation. It's just really has risen dramatically to favor the worker. But people don't know about that, and that's what my job is all about.
And what are some of the protections workers have now against being fired that you can use as ammunition and going to bat for them?
Certainly, one area is retaliation. So if you complain in writing, hopefully our listeners do that. It's, sometimes they say to me, well, I spoke to someone. No, you have to put it in writing. The minute you complain about a discriminatory act, whether you believe you've been mistreated because of your age, your race, your sex, pregnancy, whatever, disability. And that's another area, by the way. Emotional pain and suffering and emotional mental disabilities are almost they're now recognized as important as physical disabilities. So in any event, if you put that in writing and you notify HR that you're complaining, companies cannot retaliate against you. They can't demote you. They can't fire you. They can't mistreat you.
So it actually gives you protections.
Very much so.
And if you also complain about, let's say a company you think is doing something improper, not necessarily to you, but with the government, with contractors, with clients, and you complain about that, do you get some kind of whistleblower protection?
There are some laws, and I don't do much of that. I mean, that's a very highly specialized area. Sarbanes-Oxley, you're dealing with a publicly traded company. Whistleblowing is something that is not common.
Okay.
But most people, and this is the message that we want to communicate, whenever any of your listeners gets fired, they shouldn't just bow their head and shuffle their feet out the door. Every firing is negotiable, and I'm sure we'll talk about how you can improve your situation.
And we talk about firing. We'll also talk about a laid off or maybe a mutual situation where you just want to leave. It's not the right situation. They may be offered some kind of package. They may be offered to waive rights, and you can help possibly review what's being offered, review their rights, and possibly negotiate a better package.
All the time. And you just said something that's very interesting. This is a fairly sophisticated strategy that I've used successfully in my career. Let's say you're not happy at a job, but you've been there a long time and you were thinking of resigning. Well, never quit, Ken. Your listeners have to know that is the worst thing you could ever do. If you were on the verge because you can't take it anymore, consider hiring a lawyer or going into yourself to HR and telling them that you are not happy at the job for the following reasons. You feel it's in a hostile work environment, or you're a victim of discrimination, or you're a female who's not being paid similarly to men and there is a violation of the Equal Pay Act, etc. And what you want to do is perhaps get the company to avoid a problem and let you out of the job and give you a severance package at the same time.
And it's a mutually agreeable situation. You get rid of the employer and they get rid of you, and you part company on good terms and without litigation.
And I'll tell you another thing. That's correct. So correct. And I find that many lawyers in this area, they don't negotiate a severance the right way. They're always making threats and demanding and very aggressive. And I have learned in my career, you get more with sugar than you do with spice. So what I do is, and I get a lot of compliments from opposing lawyers and HR people that I work with because I'm negotiating with them. I say to them, I'm not here to threaten litigation or anything. My client's been here for 20 years. Ken worked here. He made the company millions of dollars, or saved the company millions of dollars. He's not feeling well. You know what? Let's talk about a package and let's see if we can get him out of there. And more often than not, I'm told later that was a very refreshing way of negotiating, and it usually works.
And now, what are other areas that you're involved with? You mentioned hostile work environment. What exactly does that mean? What should someone do about that if they believe they're a victim in a hostile work environment?
Most people don't understand. They think that if they're being screamed at by the boss, that they have rights. They don't. A hostile work environment specifically applies most likely to a sex harassment situation. So if you're working with a boss who screams and carries on and you're not happy, you may not have any actionable rights. If you are working in an environment where someone is creepy or repeatedly asks you out on a date or makes a comment about your attire. I had a case I was defending last week, literally, an executive who had been working for an insurance company and basically said to a subordinate, you're the whole package. And the subordinate didn't like that and reported that comment, and my client was terminated. So, you got to be very careful about what you say. And on the reverse is true. If it's of a sexual nature or it's anything to do with, some sort of a hostile, intimidating work environment in a sexual way, then you have rights that you can assert.
Does the company still have an obligation to provide training so that
They always do.
So you don't, say something bad? And is there, is it 3 strikes you're out, 1 strike you're out?
No, actually now most companies are strictly liable for the actions of their workers. So you have to get training. There's a new law that was enacted a couple of years ago, and you have to be trained, and you got to be very careful in what you say.
So you don't have a right to a nice boss or a good boss.
No.
But you cannot be bullied. You cannot be discriminated against. You cannot be teased or taunted because of your religion, your sexual preferences, your age.
That is correct.
Your orientation.
And in that situation, we talk about hostile work environment. If you can prove that a comment was made because you're older or you're gay or whatever, and you're in a protected class, right?
Or your religion, let's say.
Absolutely. Then you do have a hostile work environment claim.
And what's the age when your rights kick in?
In New York, it's 40 to 70. bottom line is...
So be nice to senior citizens.
Very much so. But most senior citizens who are terminated think that they have rights. They have an age case just because they're 67 years old and they were fired. The answer is probably not. The Supreme Court has ruled that companies have the right to lay off people merely to save money. And most senior executives are making more money than younger workers, and that in of itself is not going to fly.
So, but you can be laid off, but if there's collateral damage, if someone calls you names or defames you based on those protected areas, you may have rights.
Yes, and that, I think the most important thing to remember is that if you feel that you're being mistreated, you probably are. And as you mentioned at the top of the show, you might want to speak to a expert, an experienced labor and employment lawyer, just to figure out whether or not, where there's smoke, there's fire. And many times I'm amazed by people's sophistication. They sense something is wrong, and they're right. And there's a lot you could do about it. You can go to the company and complain. You can hire a lawyer to negotiate an exit. You can wait till you're fired and then try to do better. I mean, there's all kinds of strategies.
Or you may want to put them on notice about the hostile environment and put the ball in their court.
Very much so.
And you may want to consult with a lawyer such as yourself before you're doing that to find out the appropriate language and who to speak to.
And many times I will write for a client a draft of the email that they're going to send to HR. Just like, as an example, if you get a poor performance review, don't just refuse to sign it. Write a respectful rebuttal and show that the review is subjectively unfair or factually incorrect. Then you really have something, because then if you're fired for honestly saying, I think that I'm being mistreated because I'm a female, I'm the only female on the team, and all of a sudden my boss, who was a woman, is now replaced by a male, and the male boss is not really happy with, it looks like they don't like women. There's something wrong here. And
especially if your prior review was glowing.
Exactly, because a leopard doesn't change its spots.
So you don't have to take this stuff, but they should consult with you before responding.
Technically, it's probably smarter if a person comes to me before an activity or conduct is done, right? Because I can give them strategies that'll be very effective. Sometimes if you wait until after you're fired, you've lost some of your leverage.
Okay, and of course, at all times, want to help people protect your rights. I just remind everyone we're talking about employee rights, and our guest is Stephen Mitchell Sachs, with offices in New York, and he handles cases all over the downstate area. He's also the author of the book Fired, Protect Your Rights and Fight Back If You're Terminated, Laid Off, Downsized, Restructured, Forced to Resign or Quit.
And like you, Ken, I'm a Long Islander through and through. I grew up in Oceanside when I went to Stony Brook University, and I have an office in Garden City. And, so I'm local, and I'm here to help people.
Now, if someone has a question or concern about their situation or is concerned about things that may or may not happen, are you available for a consultation?
The way it works is I usually get many emails, and I can give out the email later. So I'll get a question in an email, and if I feel that the question is, reasonable, or it's, I can help the person, or if I get a phone call, many people, find me online. They pick up the phone and they call me on my. I have a 917 number that is a business line 24/7. I will talk to them briefly at no charge. Then, if I feel that I can help them, you had asked me this earlier, I charge a consultation fee. It's not a large fee. I charge $300 for the first hour. 1 hour is all I need to really learn the facts from that individual and give them advice, strategies, tips, and guidance. The reason I have to charge a consultation is because I want to have a lawyer-client relationship such that everything that I discuss and what I learn is privileged and confidential. And I also review documents. You might send me your offer letter or your employment contract or a separation agreement. And I can't just look at that unless I'm your lawyer. So I charge a initial $300 1 hour consultation fee to give people advice. Now, most of the people that come to me then hire me to negotiate a better severance package. More than 80% of the time, truthfully, I do better.
And so someone's being asked to sign an agreement when they start, when they leave. They have the right to have that reviewed by a lawyer, and perhaps the lawyer can negotiate it, change it around, negotiate some more favorable terms.
I'm shocked that most executives sign employment agreements without negotiating them or having a lawyer look at them. I could in one little point justified the $300, like I could say to them, you're an at-will employee, an executive who's, by the way, leaving a very good job to take a new job. I'm not so thrilled with that unless you get some job security. But I could say to you, you know what? Why don't you negotiate if you're terminated any time, not for cause, you get a guaranteed 3-month severance package, or they have to notify you and give you a month's notice or notice pay before they terminate you. Those are the things that people never think about.
And even if your termination agreement or your initial agreement provides that it has a non-compete clause, you might be able to negotiate a better non-compete or more limited non-compete
all
clause.
the time. There are 3 areas of non-competes. One is you can't work for a competing company. Another is you can't solicit customers or vendors or whatever. And the third thing is you can't woo away employees that you work with. That's the one that'll be most likely enforced. Courts don't like Pied Pipers, But as far as like not being able to work for a competitor, the odds are very, very low that you'll be constrained even if you're sued. But the point is, and what you brought out before is, people should confer with legal counsel, with experienced labor and employment lawyers to look at their contract before they sign it. Certainly never sign a separation agreement, especially if you've been there for, a couple of years or more and they're offering you, 12 weeks of severance, because every firing is negotiable. I can get you more severance pay. I can get you notice pay. I can get you more COBRA paid for by the company, outplacement assistance, favorable letter of reference. It goes on and on and on. Oh, here's one. A lot of my clients towards the end of the year will be fired to be deprived of a year-end bonus, a commission. They might be close to a vesting of a pension or profit sharing plan. They might be close to some equity, stock may vest, but they're terminated right before. If that happens to any of our listeners, they really shouldn't take that lying down. They should speak to a lawyer to see if perhaps they can negotiate to get that benefit that they were expecting and that they would have gotten but for the firing.
And you mentioned earlier, someone sees some wrongdoing, some hanky-panky, something that may be corrupt, maybe some kind of favoritism. Should they notify human resources? Should they notify someone else? Well,
if you're a female and you're being mistreated because you think of your gender, or you find out that a similarly situated male colleague is getting a lot more money than you are, and he's got less seniority and less education, right? There's a violation of the law there. So absolutely, you should speak up.
And what if it's not affecting you directly, but you see something that you think is going on?
In that situation, I'm more of the, loose lips sink ships and keep your mouth shut. I mean, I don't recommend that people, run around and try to protect other people. I think they should worry about themselves.
What if it's some type of corruption? It might break some law.
It depends on, what we're talking about.
Okay. What are some of the other situations that come up in employment, ongoing employment, leaving employment, that you can help people with?
One of the things is, protecting your reputation and making sure that you don't get a negative review about yourself, right? A reference. So when you're negotiating the severance package, there's usually a clause, a disparagement, non-disparagement provision that says that you're not allowed to talk negative about the company. So what I recommend is that people make the company say the same thing, that they won't disparage you. And if they say, I can't do that, then ask for like the names of 3 or 4 of the people, the higher ranking people, the boss that you worked for, and maybe an owner or 2 to agree that they won't give a negative reference. And also put a sentence in the agreement that says when a prospective employer calls that the company agrees they will only confirm dates of employment and positions held. That if they violate that, right, if they give you a negative review, you could sue them for breach of contract.
Could you ask also for a positive letter of reference when you're leaving?
I always do. And let me tell you, short, simple is better, Ken. So what I recommend is something like this. To whom may concern, Ken worked here from blank to blank as a blank. He performed his services competently, and we wish him well in his endeavors. That's the best type of letter of reference that you can get.
Okay. I'd like to remind our listeners we're talking with Stephen Mitchell Sachs. He's also known as the employee's lawyer. He's also the author of a new book, Fired: How to Protect Your Rights and Fight Back If You're Terminated, Laid Off, Downsized, Restructured, Forced to Resign, or Quit. What are some of the other things that you cover in your book, Steve?
Never quit. We talked about the book really is, I hammer that theory home. See, if you quit, Ken, you're basically not getting unemployment unless you can prove it's a constructive discharge, and you're walking away from a severance package and potential benefits like we talked about, like pension, profit sharing that might be vesting shortly, commissions, bonuses, etc. So that's my first rule. Never.
And it's also not going to look favorable to you in the future if you quit a job.
I'm not so sure. Like a lot of times I negotiate with a company where they don't care what you say.
Okay.
So if it's nobody's business, let them fire you, collect unemployment, right? And maybe it's better for you to be able to say, I decided to leave. Why did you leave? You can structure, well, I thought, I wanted to do more in a certain area.
Well, downsizing is a common term these days, too. So maybe that's a nicer word.
The stigma of being terminated is not like it used to be. Okay. Also, I want to give a tip to our listeners. A lot of people sign a separation agreement and they file for unemployment immediately. Well, under New York law, if you get unemployment and get your severance pay within 30 days of your separation date, you forfeit unemployment. So what you want to do is you want to push back in the agreement. You want to push back the day you're going to get your, let's say, lump sum, your $25,000 in severance pay. If you're fired, let's say, on September 15th, you want to wait until the payroll period of like November 1st so that you can get unemployment and severance at the same time.
And again, you mentioned health benefits earlier. They can be very expensive, very important. So you want to stretch those out for as long as possible.
Correct. And it's so important. And you want to know something? Most of the time when I negotiate, if a company is not willing to give my client more severance pay, one of the things that they are willing to do is give them more COBRA benefits. So it's a fairly easy ask. You just know that you got to ask for it.
And again, they don't have to ask for it, but you can ask for it for them.
Either way, I mean, in the book, I've laid out, there's chapters on how to negotiate a severance package and all the fallback, like what to ask for first, and if you don't get it, settle for a little less. But you see, without people knowing these things, they're going to jump into a hole. I want them to jump into a hole, but with their eyes open.
So you're telling them what some of their rights are, what some of the things they should ask for, and how to negotiate for them.
And I give them agreements and letters to send so that they really have, value in this book that I've created.
And as you mentioned before, they can always contact you to see if they're on the right track or if you can do better for them.
It's an honor and a privilege. May I give out my number, how they can find me?
Absolutely.
Okay, so for anyone that is interested in speaking to me briefly, there's no charge. If you want to call me, it's my number is 917-371-8000. That's 917-371-8000. You can go online and send me an email, which is Stephen Sack, ATTY, at hotmail.com. That's Stephen Sack, attorney, but it's ATTY, at hotmail.com. My webpage is stephensack.com or theemployeeslawyer.com. If you're interested in purchasing the book perhaps and you can't get it in a bookstore online, you can go to legalstratpub.com to get a copy of the new book. Anyone that hires me for the $300 consultation will get this $34.99 book for free anyway. And frankly, I just want other people to know that when they hire me for the 1 hour, then if they want me to negotiate a severance package, there's no money up front. I just get 1/3 of the gross of the extra minus the $300 they paid me, and if I get them medical, it's a gift. And people are typically very happy with that because there's no downside.
And it's a win-win situation.
You're betting on me, and people are happy.
And it's really on the extra.
Only on the extra.
Okay.
If I don't get you any money, I don't get a penny, and it's my pleasure, truly.
And on your websites, do you have other tips for employees?
So much. I have, there's so many articles that I've published and blogs, and people should just go online, find me, with stephensack.com or theemployeeslawyer.com, and they will get so much information. And by the way, Ken, this is not my only book. I've written I wrote a book for women called The Working Woman's Legal Survival Guide. I wrote The Employee Rights Handbook, which is a treatise on employee rights. But this book I decided to write because it's my legacy. It's basically what I do all day long as a lawyer. I, review separation agreements with clients, and then I negotiate better terms for them. And so I decided to just give as much as I could back to the American public. It's what I've done in my whole life.
And you've been involved in this field for a long time. I just want to ask about the evolution in terms of the nature of the claims, the number of claims. What have you seen happening over the last 5 or 10 years?
Well, like I said, the laws have changed dramatically to favor the worker. So people have to know that they should assert themselves. Every firing is negotiable. If you get fired, don't just, bow your head and shuffle your feet out the door. Think about going back in, requesting another exit interview, negotiating a better deal. Most of the time, you will get more money. And think about it. It's a very stressful time in your life. If you don't have a job, you can't pay your mortgage, your kids may be in college, your wife may be sick, etc. You need extra coverage. You need COBRA benefits paid for by the company. Be sure to assert yourself. Know what you're doing. Know that out there are, tools like this book, and I'm available, and people really can take advantage of that.
What if you want to stay with the company? Can you negotiate working in a different spot? Can you get more a bigger workspace and quieter workspace?
It's a great concept. What I've learned is when they want you out, you're gone.
What if they're not threatening you, but you'd just like more space to be in a different apartment, to work on different projects?
Always try but you have to have, people have to view you in the right light. If they think you're a troublemaker or a pain in the neck, and you just don't want to work with your boss because you can't get along, I don't think you're going to get a transfer.
And now you mentioned earlier some do's and don'ts, and in the few minutes we have left of this program, if you're not happy, if you disagree with a review, if you disagree about how a project went or a deal went, what should you do?
Put it in writing. People really...
In a note to the file, a note to the supervisor.
Very much so.
Push back on just to clarify the record.
Especially if you're in a protected class, especially if you're a female, if you're a person of color, if you're pregnant.
About a certain religion.
Oh, by the way, if you're pregnant and you're fired, first of all, the minute you get pregnant, tell the world. If people are afraid because then no. You have to tell your boss that you're pregnant. Tell everyone, run down the hall. I'm pregnant, I'm pregnant. Because now if they do anything to you, if they demote you or they fire you, you run to a lawyer like me, because I might be able to get you a lot more money. There was a case that I handled. I had a jury trial in the Bronx with Scott A. Lucas, who's a brilliant litigator. We won a $6.6 million jury verdict on behalf of 3 pregnant women who were fired within 6 months of telling the company they were pregnant.
Should you also let them know if you're in a protected class and it may not be obvious?
No.
Okay.
And, like a lot of women who are pregnant, don't tell the boss that you're pregnant when you're looking for a job. Like, when they interview you, keep your mouth shut. Tell them after they hired you and you start your first day, let's say you're in your 4th month, then you could tell your boss. And be sure you do in writing, right? So that no one can say, I didn't know.
And you should, if it comes to the pregnancy, you should never leave your job and say you want to stay home with the kid. You want to get the leave, and then you can always negotiate whatever you want to do.
Absolutely. So you should have been a lawyer because of all the lawyers you interview in your career. But
that's a very important point.
Very much so.
Don't waive your rights. Don't leave the job. Work out the terms, and it might be negotiable about your maternity or paternity leave. And then if you decide you don't want to go back, someone like you can help them.
Here's another trick that I want our listeners to know. Many times they think that it's better to go out on FMLA leave, but you can be fired while you're out, even though the law says you're not supposed to be guaranteed your job on the way back. My recommendation is if you go out on short-term disability, which might also translate into long-term disability. That's a better thing. You might get 6 months of full pay as opposed to 12 weeks of FMLA leave that you have to use up your vacation pay as well.
And someone can always consult with you on the best options if they face those questions.
And that's why what you said earlier is so true. If people come to me before a problem develops, right, and they get preventative advice, then they can utilize the strategies and tips that we talk about before as opposed to later.
And they're going to come out better and be on stronger legal ground.
Typically, that is correct.
I would like to thank our guest, Attorney Stephen Mitchell Sachs. As you've heard, he's the employee's lawyer, and it can be reached at stephensack@hotmail.com. If you missed any portion of the show, you want to hear it again, please don't hesitate to listen to the podcast at nccradio.org. And please join us next week at this same time on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York, for another program on Law You Should Know.